Okay, I'll share the slides again. We stopped at repudiation of contract, remember? We stopped at repudiation of contract and okay. So we also touched upon the aspect of breach. 1 minute. Yeah, we touched upon the aspect of breach of condition and breach of warranty. Now, what happens in case it is a breach of condition? I just want you to remember two things here. In case of breach of condition, that means it would amount to contravention of a significant term in the contract. So you have just two options there. The party would have two options. One is repudiation of a contract and two is aggrieved party can sue for damages. What happens in case of warranty, which we just discussed? In case of warranty, there are again two options. One is you can call for rectification of the breach, that is to make to set the breach right, rectification of breach, and two for sue for damages. Generally speaking, these are two options: breach, rectification of breach, and sue for damages. And in case of breach of condition, it would be you repudiate the contract and the aggrieved party can sue for damages. Normally, like in the contractual world, it is normally advised in case of breach of warranty that don't go and you repudiate the contract. However grave that breach may be, it is better that you just sue for damages, and that would be the right option, or you can just call for rectification of breach. Now, the test is whether to understand whether the specific statement or a covenant in a contract is a condition or warranty. The test there would be whether the statement or covenant hits the root of the contract or displaces the primary understanding between the parties. So for this, we had gone through the case law of Pozzard versus Pierce, the Queen's Bench case during the last class. So it's essentially the same thing. We also went through Hong Kong First Shipping versus Kawasaki Kaizen Kaisha, which was a landmark English contract case law, which came up with the term of innominate terms. And innominate terms are terms which cannot be categorized as warranty or condition, and it has a hue of both. Next is, what are the remedies? Remedies, by and large, broadly speaking, two basic remedies. One is you claim damages for breach of contract, and two is specific performance of contract. Now, here about damages, I want you to know now again whether it's breach of condition, breach of warranty, breach of innominate term, right? Next is specific performance of contract, that is you ask the party through the code of law to perform his or her part of obligations, or or her part of contractual obligations. So regarding damages are awarded to compensate for the loss of the aggrieved party. It's the theory of causation, that is cause and effect theory, would be examined. Next is the question of whether the damage, the loss that is caused and the loss that has occurred and the cause of it, whether it has got a direct nexus, it is directly connected, or there is a remote connection there. So the case of Hadley versus Baxendale, really exemplifies this concept and says that a claimant may only recover losses that may reasonably be considered as arising naturally from the breach, or those which may be reasonably be supposed to be in contemplation of the parties at the time the contract was made. So it should be a natural occurrence. It should be something that could have been really foreseen. It should have, a real proximity. The proximity of damage would be really assessed here. Damage to damages, so accordingly, damages would be awarded. The proximity of cause to the damage would be examined, which should not be remote in nature, and accordingly, damages would be awarded. Next is again, in Jackson versus Royal Bank of Scotland, the House of Lords held that the time to determine which was reasonably foreseeable was the time at which the contract was made, not the time at which it was broken. So damages may be liquidated damages, as we learned during the last semester. I remember teaching you this. Damages may be liquidated damages ascertained by the parties as a genuine pre-estimate, or unliquidated damages which will be assessed and awarded by the court once a petition is filed before the court. It could be even non-pecuniary damages. Example, in Dyson versus Sampson's case, 1971, there was a wedding which took place, and the bride actually contracted the services of a photographer. And there, the photographer actually, he missed to attend the wedding, and he would not honor the terms of his contract. And finally, the bride filed a case before the court saying that he couldn't capture those special moments. The court, now, of course, the defense of the photographer was, well, I couldn't come, but what was the actual material damage that was caused to you? What significantly did you lose? It is just that you did not get your photographs. But the court said that you can assess damage not just in pecuniary terms, not just in monetary terms, but also in non-pecuniary terms. It's not always monetary terms, but also in non-pecuniary terms. It's not always in the commercial sense, but also with respect to personal, social, and family interests that needs to be considered. And the doors of the court is not closed to just awarding damages for just commercial terms, or in pecuniary terms, or in monetary terms, but also for mental suffering. And therefore, the court should think in such circumstances, and the parties to the contract has a right to damages. So this was held in Dyson versus Sampson. Again, the next option or the remedy for the aggrieved party in a contract is specific performance of contract, and again it would be rescission of contract and also injunction. What is specific performance? It is an equitable relief that is provided to the aggrieved party where one's contractual obligation is really trespassed, with the promises or the rights of a party under a contract is trespassed, or the other party does not perform his or her part of contractual obligation, as a result of which there is a party who is aggrieved at the other end. So the court would normally demand the other party who is repudiated or who is avoiding his contractual obligations to come forward and comply with the terms of the contract and fulfill his or her part of contractual obligation. So this is all. Apart from rescission, of course, you have injunction. Injunction, again, I remember teaching you during the last semester, it is just like bringing a cease and desist order or bringing a stop order, and it depends upon the facts and circumstances of the case, and that may be awarded either, it can be permanent in nature, interlocutory, or even mandatory. So this is all for your contract law. We have completed with the termination and also about breach of contract, the concept of breach of contract, and the remedies the remedies for breach of contract. So the next class we are going to discuss about maybe we'll go through a revision and you can sort out your doubts, but your syllabus as of now is already complete. Get ready for your exams. And I've already posted the pattern of the question paper online. I also discussed about important questions. I've also told you during the inception of this class in another, the previous video, saying that questions like promissory estoppel is a must, and it is important, and it has to have case laws such as Dennison versus Dennison, and Combe versus Combe, and Justice Dennison, who spoke about that promissory estoppel is equitable remedy and it cannot really displace the concept of consideration. So all these aspects must be there. Walton Stores case is a very, very important case. Combe versus Combe, in which Justice Denning spoke about this. It is Combe versus Combe. So these cases are very important. It has to find its place in your answer. So then I gave you again yet another important question. Of course would be the essentials of contract, and I already discussed at length at the inception of this class, which is just an hour back. And yeah, it was just in our back. So, you can go through the video recording that also will be posted online. Just go through carefully and meticulously. And if you have any question, then of course you can ask me, and we will meet for the next class the same time next week. Bye-bye.